Hello, I'm Sharika, and today I will be discussing the contemporary relevance of the ancient legal maxim. I am not able to pronounce the word, and I will just highlight it in the video, mm, which means whoever owns the soil owns everything up to the sky and down to the depths. Although this principle once formed the foundation of English land law, the literal interpretation no longer fits the realities of modern society. Today, I will examine how the maxim applies in modern law, particularly in relation to airspace and subterranean rights. I will also critically evaluate the significance of Bocardo versus energy, a case that reshaped the understanding of deep underground ownership. This maxim originally suggested absolute, unlimited vertical ownership. Historically, this made sense because land was not used in complex vertical ways. There were no aeroplanes, drones, skyscrapers, or deep underground infrastructures. However, modern legal scholars argues that the maxim no longer provides a workable framework. The modern approach focuses on reasonable use and enjoyment rather than infinite vertical rights. Society today requires flexibility in how airspace and subterranean land are used. Aviation, telecommunication, large engineering projects, and energy infrastructure demand that some areas above and below land be treated as public or regulated spaces. As a result, the maxim still exists, but its application is significantly restricted. Moving on to modern airspace law recognizes two important zones. The first is lower airspace, the area a landowner can reasonably use. This includes the area around buildings, roofs, and the immediate air above the land. Interference here can amount to trespass, as shown in cases like Kelson versus Imperial Tobacco, where even a minor intrusion into airspace was actionable. The second zone is upper airspace, which is considered public. This principle comes from Bernstein versus Skyviews, where the court held that aircraft and aerial photography at normal flying heights do not trespass on landowners' right. Aviation statutes reinforce this by giving aircraft lawful access to upper airspace. This reflects a modern balance. Landowners retain control over the space they realistically use, but not over the vast heights necessary for aviation and public transit. Going downward, the traditional assumption was that landowners owned everything beneath their land indefinitely. But long before Bocardo, legislation had already carved out major exceptions. Natural resources such as petroleum and minerals were vested in the crown. This means that even if these resources lie beneath someone's land, the landowner does not own them. Today, underground space is used for far more than natural resources. We have transportation, tunnels, fiber optic lines, sewage systems, heating systems, and emerging technologies like carbon capture and storage. These developments mean that modern law must determine how deep ownership should realistically go and how to balance private property rights with major public infrastructure needs. This brings us to the landmark case of Bacardo versus Star Energy. In this case, Star Energy drilled pipelines at depths between 800 to 2,900 feet below the claimant's land. These pipelines were extracting petroleum that belonged to the Crown. The key question was whether this deep underground drilling amounted to trespass. The Supreme Court held that it did. This confirmed that landowners do have extensive subterranean rights. However, the court awarded very small damages because the drilling did not interfere with the claimant's actual use of the land. This illustrates the modern approach, recognizing the principle of ownership but limiting its practical effect when public infrastructure is involved. This case became a turning point. It confirmed deep ownership but highlighted that such ownership is limited by the public interest and statutory schemes. Today, English land law adopts a functional and practical approach. In airspace, landowners control only the space necessary for ordinary use. Aviation is protected by statute, and drones and cranes are regulated through the concept of lower airspace. In subterranean space, ownership is significantly limited. Petroleum belongs to the Crown, and many underground developments are authorized by statute. Courts also consider public interest and modern infrastructure needs. Modern scholarship suggests that the future of land law lies in greater statutory clarity, especially concerning the deep subterranean space. Some jurisdictions have already implemented clear depth limits, reflecting the idea that landowners do not need and cannot realistically use an infinite vertical column. Overall, the maxim survives symbolically, but its literal meaning is largely outdated. In conclusion, the legal maxim continues to influence modern land law, but only in a limited and heavily qualified way. The literal idea of owning the sky and the depths is no longer accurate. Airspace rights are restricted by aviation needs that reasonable use principles. Subsoil rights are confined by statutory ownership of minerals and the demands of modern underground infrastructure. The decision in Bocardo reaffirmed deep ownership but also showed that practical limitations apply. Modern land law, therefore, balance private rights with broader societal needs. The maxim remains historically significant but no longer provides a complete or realistic definitions of the vertical extent of land ownership.